The committee shall, in terms of the exposition in this judgment, consider the following. 1. Enabling partners in a queer relationship, A, to be treated as a part of the same family for the purposes of a ration card, and B, to have the facility of a joint bank account with the option to name the partner as a nominee in case of death. 2. In terms of the decision in Common Cause versus Union of India, as modified by Common Cause versus Union of India 2, medical practitioners have a duty to consult family or next of kin or next friend in the event of patients who are terminally ill and have not executed an advance directive. Parties in a union may be considered family for this purpose. 3. Jail visitation rights and the right to access the body of the deceased partner and arrange the last rites. And 4. Legal consequences such as succession rights, maintenance, financial benefits such as under the Income Tax Act 1961, rights flowing from employment such as gratuity and family pension and insurance. The report of the committee chaired by the Cabinet Secretary shall be implemented at the administrative level by the Union Government and the governments of the states and the Union Territories.
I've had the benefit of the exhaustive and erudite judgment of Chief Justice Chandrachud, which enumerates the prevalence of these relationships in history, the constitutional recognition of the rights to form union, in other words, what I categorize as civil unions, and the necessity of laying down guidelines to protect the non-heterosexual unions. In a way, this is a step forward from the decriminalization of private consensual sexual activities. However, the subject matter itself persuades me to pen down a few words while broadly agreeing with my brother's judgment. I've dealt with the historical prevalence of non-heterosexual unions. I've said that it is no longer res integra, that the duty of a constitutional court is to uphold the rights enshrined in the Constitution and not to be swayed by a majoritarian tendency or popular perceptions. This court has always been guided by constitutional morality and not by social morality. Pluralistic social fabrics has been an integral part of the Indian culture. I have referred to some observations from the Rig Veda and the Somdas Katya Sarigra. And then I've said the significant aspect is that the same-sex union were recognized in antiquity not simply as unions that facilitate sexual activity, but as relationships that foster love, emotional support, and mutual care. I've referred to some traditions in the Sufi traditions. Then I've said the marriage as an institution developed historically and served various social functions. It was only later in its long history that it came to be legally recognized and codified. However, these laws regulated only one type of social historical union, that is the heterosexual union. It would thus be misconceived to claim that non-heterosexual unions are only a facet of modern social milieu. The objective of penning down this section is to provide perspective on the existence of non-heterosexual unions, despite continued effort towards their erasure by heteronormity of majority. The non-heterosexual unions are entitled to protection under a constitutional scheme. I have referred to the necessity of recognizing what I have categorized as civil unions. The judgment of the Chief Justice notes the right to form union is a feature of Article 19 and 21. Therefore, the principle of equality enumerated under Article 14 and 50 demand this right to be available to all regardless of sexual orientation and gender. Having recognized this right, this court has taken on board the statement of the learned Solicitor General to constitute a committee to set out the scope of the benefits available to such union. I agree with the Honorable Chief Justice. I have referred to the Special Marriage Act and discussed the statement, object and reason therefore. From the above, the SMA postulates a special form of marriage available to any person in India, irrespective of faith. Therefore, SMA provides a secular framework for solemnization and registration of marriage. It is here that I respectfully disagree with my brother Justice Bhat that the sole intention of SMA was to enable marriage of heterosexual couples exclusively. To my mind, the stated objective of SMA was not to regulate marriages on the basis of sexual orientation. This cannot be so, as it would amount to conflating the differentia with the objective of the statutes. Although substantive provisions of SMA confer benefits only on heterosexual relationships, this does not automatically reflect the objective of the statute.